Hello everyone and welcome back. In this video I want to talk to you about and I want to clarify the voluntary admission section of the Baker Act. And I also want to talk to you about what the Baker Act is and what it's not, and why the voluntary admission section of the Baker Act is in effect just as bad, if not worse, than the involuntary section of the Baker Act. So let's talk about what the Baker Act is. It is a statute that allows the state of Florida to take temporary custody of somebody, at least initially, and make them a ward of the state. It means that they are no longer able to make mental health and or medical decisions for themselves. Those rights are basically suspended, in effect terminated, by the state of Florida. And that means the state of Florida basically is the one that is making decisions for this person with regards to their mental health and medical decisions. And the Baker Act is typically initiated because somebody has alleged that this person is suffering from some type of mental health crisis which requires immediate intervention. Now, the Baker Act can be initiated one of three ways. It's either initiated by the police, it's initiated by a qualified professional like a social worker or an emergency room doctor, or somebody goes to the courthouse and files an emergency petition, and the court decides whether or not to grant it. If it's granted, the court orders law enforcement to come and collect this person and take them to this nearest receiving facility. Now, what the Baker Act is not, and I really emphasize this, the Baker Act is not a treatment statute. And very often we get families that call to us and they say, we'd like to Baker Act our loved one. Why do you want to do that? Well, they need treatment. Then don't Baker Act them, because that is not what the Baker Act is designed for. And if you Baker Act your loved one, what's going to happen is that not only are their rights, their ability to make decisions for themselves regarding their medical care, mental health care, not only are those going to be terminated, but your ability to make decisions for them, even if you have a power of attorney, even potentially if you had guardianship, are at least temporarily going to be suspended, terminated. You won't be able to make any decisions for them. Now, obviously, if somebody is in need of immediate services, i.e. they're suicidal, of course, we want you to be able to pick up the phone and call 911. That's what it's designed for. But ultimately, if this person is in crisis, and this has been going on for a period of time, which typically it has, then we need to talk about what other options are available. Because once the state gets somebody, if they continue to get Baker Acted over and over and over again, eventually you don't get them back, and they'll send your loved one to a state mental health hospital. And I promise you won't like when that happens, because the state of Florida is really terrible at taking care of patients who have mental health crises. So we don't want that to happen. But there are two types of Baker Act. One is the involuntary. You've probably heard of that because it's associated with the 72-hour detention. The other one is voluntary. Yeah, you can actually agree to be Baker Acted. Now, you're supposed to give informed consent, but frankly, rarely, if ever, and I've handled probably close to, at this point, 600 or 700 of these cases, have I ever seen anybody give informed consent. And what typically happens is somebody goes to a hospital, either their meds don't work and they want to be, quote, assessed for new medication, or they go to the hospital because they don't feel well. And sometimes they've done it or do it because maybe the clinician told them go to the hospital. I've seen people show up at the Baker Act facilities asking for help. And what happens is typically somebody at the hospital or the Baker Act facility will say, would you like to be assessed for new medications or to see what we can do to help you? I would. Then sign here. What you've just signed is what's known as a voluntary admission agreement. And unlike the involuntary detention, which has an initial hold of 72 hours, the hold on a voluntary basis is infinite. There's no time limit on it. And here's the other rub. If you ask to leave, which typically happens because somebody finds out that they're not getting what they thought they were going to get, you can't leave. You cannot leave. Just because it's voluntary doesn't mean you can leave. You are locked up. Your rights are terminated. Your family's rights are terminated. The only entity that gets to make decisions for you is the state of Florida and its agents, which typically means the psychiatrist at either the hospital or the Baker Act receiving facility that you're being locked up at, and they can forcibly medicate you. And so, the idea that you are, quote, voluntary is not really voluntary. It's involuntary. But there are two, parts to the Baker Act statute, and I want you guys to understand that if you show up at a hospital or a Baker Act facility and you ask to be assessed, or tell them that you need help, and you sign that document, unless they are willing to let you go, you're not going home. You are locked up. And here's the icing on the cake. If you decide to leave, or you want to leave, first of all, if you try to leave, they're going to physically restrain you. And if anybody from your family tries to walk you out, they're getting arrested. They're going to take a trip down to the county jail. So don't do that. You're messing with the state of Florida. But if you decide you want to leave, they got 24 hours to either let you go or file a petition to keep you. And that finally triggers a time frame, which is up to 5 days, for the state of Florida to bring their case before a judge. And at that hearing, you can get sent to a state hospital. You get detained for up to 6 months. So I want you guys to understand how serious this is. There's nothing voluntary about the Baker Act. Nothing. And so if you have a loved one who has been Baker Acted, either involuntarily or voluntary, because they didn't realize what they were agreeing to, then we need to talk about how to get them out. Because if the court enters an order for extended detention, I mean, we can fight that, but it's really, really hard to get somebody out after there's been a hearing, because judges don't want to go back and revisit a case. They got hundreds of other cases on the docket. Why should they go back and look at yours? You had a hearing. You may even have had a public defender appointed to represent you or your loved one. And I'm not poo-pooing the public defenders. One of my associates was a public defender. I hired him specifically because of his experience. But when you got 20 other cases on the docket, it's kind of hard to do a great job for the client. And so if you have a loved one who has a mental health crisis, then we need to talk about what options are available. Because if you don't do something about it, if something bad doesn't happen to them, I can tell you, the state will do it for you, either through the criminal justice system, because folks with mental health issues and drug issues and things of that nature tend to get arrested, or through the behavioral health system, the mental health system here in Florida, which is draconian and broken. And so if you have a loved one that is suffering, if you are, trying to deal with this on your own, call us. We've got, resources and options that we like to talk to you about. So I hope that helps. I hope you understand now there's nothing voluntary about the Baker Act. Nothing. And anyway, with that said, please give us a thumbs up. Please subscribe to the channel, and I'll see you in the next video. Goodbye.